Our main speaker, our minister, is here to address us. I'm just going to give you a short summary of who exactly he is before he addresses us. Mr. Ronald Lamola is an attorney of the High Court of South Africa. So he is one of us, so we expect him to understand our issues. He has 2 Masters of Law degrees, one in corporate law and another in extractive law, both obtained from the University of Pretoria. Since 2017, he has served in the African National Congress Executive Committee and National Working Committee. In 2021, Mr. Lamola was unveiled as one of the world's 12 most promising 112 young global leaders under the age of 40 by the World Economic Forum. Ladies and gentlemen, I give you Minister Lamola.
I was saying to the president of the LSSA that it is out of brevity that I'm here today. And I'm saying it's out of brevity because of the challenges that I'm aware the profession is facing. And the most acute one being the challenge of load shedding. So as I was waking up, I said, it's not going to help that I run away from this reality. Because load shedding is here with us. I must wake up and come here and have this difficult discussion with yourselves. And I'm starting with this challenge that of load shedding because it is affecting not only practitioners out there, it is affecting the operations of the courts. It is also affecting all livelihoods and social life of our country. It is an existential challenge that the president has identified and termed it as an existential crisis. But us running away from it will not make the challenge to go away. We have to confront it and have necessary discussions and engagements. They told me the impact it has, particularly on small law firms across the country, and I'm aware of the impact it has on the operating hours of the courts. And it is against these backgrounds that we are in engagements with the newly appointed Minister of Electricity to see whether it's technically feasible to exempt courts from load shedding. But we are also engaging with the Department of Public Works on alternative sources of energy for the operations of the courts, particularly the busy ones, because we may not be able to afford to do it for each and every court in each and every part of the country. That is the reality. But we are looking whether can't we find a way of augmenting the current resources we have in some of the most busiest courts in the country. Because some of the courts do have generators and so forth. But the challenge as it degenerates and exacerbates has proven to us that even some of those generators that we have in these courts are unable to cope with more than 2 hours of load shedding. So that is a discussion we are having with Public Works. How do we then help to augment this challenge so that people are still able to access justice? Practitioners are still able to ensure that their clients access justice. We gather here today when the Department of Justice is also hosting a conference on the 25 years existence of the Constitution. This is the last day of the Department of Justice conference on this topic. The conference started on Wednesday. It will be closed today. And from here, I will be going back to the conference. The conference has been looking at the lessons that we have learned in the past 25 years of the implementation of the Constitution. It will also give us guidance of what we need to do to continue with the project of constitutional development in the next 25 years. As lawyers, I'm sure you will agree that the Constitution of South Africa is not just a rules book by which we live by. It is a transformative tool in our hands in a society that was defined and shaped along racial lines, ethnicity, class, and gender lines. The legal profession has also evolved since the advent of our democracy. President Cyril Ramaphosa, addressing the conference of the Department of Justice on the Constitution, urged the conference to debate whether transformation should only be measured by the stats we brandish on the transformation of the judiciary, on what the executive has done, and also only on the laws that we have passed in Parliament. He said, is it not time that it should be measured on also the content and the implementation of some of these laws that we have passed, and also on the contents of the judgments that have come through our courts? This question is also relevant for the law society. Are we as legal practitioners contributing to advance in terms of jurisprudence that will help this society to transform? The report of the Department of Justice on the judgments that have gone through our constitutional courts indicate that the judiciary has played a very crucial and important role in advancing and advocating and developing jurisprudence on socio-economic rights and advancing the project of the Constitution to develop it. And there are lots of cases that you can name, the Subramani case and many others that dealt with the advancement of the socio-economic rights as enshrined in the Bill of Rights. As practitioners, we should also take stock as to what has been our contribution to advance these socio-economic rights as enshrined in the Constitution, and what should be our contribution going forward. The legal profession has also evolved in these 25 years since the advent of this Constitution. Going into the next 25 years, the conference should seek ways that will make the legal profession an indispensable cog of our democratic project. Prior and post-1994, lawyers were in the center of our democratic project because you had to participate in the drafting of the Constitution and the drafting of the new laws that came about after the Constitution was adopted. With an evolving society, the profession is also facing an existential crisis, where society is now evolving. The social relations are also evolving, and social dynamics are also being rearranged, and including the economic dynamics. Now people can just go into ShopRite or online, they get a template of a Lamola agreement or any type of agreement that they may want to enter into and use it for whatever transaction that they want to do. And there are various examples that some of the work that were only done by lawyers in the past are also sometimes taken by other professions. So this conference will also help you shape what a law firm of the future should look like. What will be a law firm in the next 25 years? Still continue to draw its clients from, who must see the work of lawyers as an important cog of whatever transaction or whatever rights they want to advance in a constitutional democracy. This will not happen when ourselves as government do not enable an environment that is conducive and that enables the practice of law to be possible. And it's for that reason that I started with the issue of load shedding. I'm also aware of the contribution that you are making as lawyers to make the master's offices to function. The Legal Practice Council and yourself as a law society have been raising serious complaints with some of the challenges of maladministration, malfunctioning, and lack of efficiency in some of the offices of the masters across the country. It is a challenge that we have zoomed into, working with the masters offices, but we have come to the conclusion that the best and the only solution that could help provide and improve the efficiency in the master's office is modernization, is digitization, and is the filling of the vacancies in the various offices, which is a work we're undertaking. There has also been a back and forth on some of the regulations that emanate from the Legal Practice Act, the LPA. And I will only cite one example. And I was saying to your president that, I have learned in these 3 years in this post that lawyers can debate for more than 10 years a policy issue. It can be debated into paralysis. So one of it has been this silk issue that has been back and forth between ourselves, the Legal Practice Council, and the various stakeholders in the space. We are of the view that we have now reached a point where it is now for the president to promulgate the regulations. But there were some few issues that he raised, which we took back to the LPC. I'm hopeful that soon we will find a solution and these regulations will be promulgated. The second one has been the Legal Practice Code, the Legal Sector Code that will have to be promulgated in terms of the BBEE Act. It was also very contentious, back and forth, until we said, let's get the views of everyone. And we said, let's lay the basis with the current consensus that has emerged. And the codes were taken through, gazetted. They are now with the DTIC to gazette them finally after a lot of public inputs and comments. And that's where they are. So they were asking me, what is happening with the Legal Sector Code? I've seen the letters that were written, I think is the Black Lawyers Association, Nadel, I'm not sure if the LPC, I think so. So I also forwarded the letters to the relevant authority that has, by law, the power to promulgate the codes. And I support that the codes must be promulgated. I have written a letter of support. That is as far as my hands can go. But as a profession, we also have a responsibility, as I've said, to look into what happens in the next 25 years. How we reposition the profession, and also how it continues to preserve itself as it has always been known as the noble profession. The legendary late Justice Aya of India, who incidentally was also a Minister of Justice, and then ultimately went to become a judge of the Supreme Court of India. Is known for several remarkable achievements in the legal profession in India. So I hope that you are not going to be suspicious of my intentions. I don't have the same intentions as him, from being a Minister of Justice to be a Supreme Court of Appeal judge. So much so he was hailed as the Mahatma Gandhi of law in India. But perhaps what he is mostly renowned for is his book, Professional Conduct and Advocacy. In this book, Justice Aya explains what is meant by the phrase, the noble profession. He says, as I quote, the most brilliant and attractive of peaceful professions, with the responsibilities both inside and outside it, which no person carrying on any other profession has to shoulder. Close quote. In other words, the legal profession is nothing without its ideals and its ethics. As lawyers, we are the upholders and the protectors of the law. It is a service we give to society, and that is how we have earned the title of the noble profession. The question then becomes, as a profession, are we doing all we can to keep the profession's ideals and ethics intact? Because this is also an important existential component of the profession. When society can trust us on our services and also with their resources and their aspirations. Whilst I'm aware that there is a legitimate expectations from the profession for government to play its part to transform the profession, I will continue to encourage you to review the departmental statistics on the briefing patterns which are always available in the department's website. And we are doing this to lead all the other stakeholders who have got the power to brief, like the private sector, like other state organs that do not brief through the state attorney. Our states have always been above 80% in terms of responding to the demographics of the past, in terms of empowering the previously disadvantaged. But what is now emerging because of these states that are available, the legal profession is now saying, no, we see that at least you are doing something. We can see from the stats of the department through the state attorney that you are indeed empowering black practitioners or the previously disadvantaged, as it is termed there. But we see only repeat briefings. So a new challenge is emerging because of the work that is happening. So we are also looking into policies that will then ensure that the relevant, skilled and competent person is appointed, recognizing also the need to empower and to resolve the injustices of the past. And we are hopeful that the journey of the legal sector code will then help us to also encourage the private sector and also other state organs to do the same, to comply with the BEE codes. We continue to engage with the Legal Practice Council on a number of issues that some of them I have already raised. And we view the Legal Practice Act as a living document that must continue to evolve to maintain and ensure that the legal profession remains relevant and continue to develop itself and acclimatize and evolve with the changing conditions in society. And there are a number of provisions and regulations of the Act that we continue to promulgate on the basis of what the LPA expect us to do. And I know that there are also some that still needs to be promulgated on the basis of the same LPA Act. We remain open to be engaged on some of those laws and to be advised by the Legal Practice Council. And lastly, we also remain open to any suggestions. As I've said, we're engaging with Public Works and the relevant department with regards to load shedding across the country. But we remain open to any suggestions that may also come from your conference, how do we find innovative and creative ways to ensure that the wheels of justice continue to roll while we are having this challenge? Because this challenge is now here, it is with us. We must all put our hands on the deck and try to find a solution so that the courts and the wheels of justice, they continue to roll. Thank you very much. I wish you all the best with the AGM.